Hi everyone, hello and welcome to our live event today, which is about the new AML and CTF obligations. Introducing our wonderful instructors today, Gina and Charles. They're the ones who probably breathe AML and CTF, so perfectly placed to take us through today's topic. Like I mentioned before, Charles and Gina are partners out at 𝗵𝗺𝗃𝗁 Lawyers based in Sydney within their corporate and commercial team. We're also joined by Jane Harris, who will be helping me moderate today, also from 𝗵𝗺𝗃𝗁 Lawyers. And like I said, Jane's a familiar face to our Nuggets, as she's one of our superstar presenters who does our monthly tax updates with us. So everyone, please give a warm round of applause to welcome Charles, Gina, and Jane today. How are you all?
We're good. Thanks, Vicky. Hi, everyone. Nice to see some familiar faces and some new faces out there today. We've got a lot to get on with today, so I won't spend too much time here at the front, but I wanted to bring in some backup today to talk about this topic. Everyone's been asking about it, so I'm very excited to introduce Gina and Charles, my colleagues, who are going to take us through what does it all mean, who has to register for this thing, and what do we do next. So without anything further, I will hand over to Gina.
Thanks, Jane. Welcome, everybody. So, as mentioned by Vicky, so I work in the corporate and commercial team, dealing a lot with mergers and acquisitions. So this area will affect me. And Charles here does a lot with financing as well. So again, another area which is affected by these new, we call them Tranche to AML/CTF obligations. This session is really divided into two sections. The first section is really about what are these new designated services that are applied to accountants and other professional advisors. So I'm going to take you through those. I'll try to make it as interesting as possible. There are 9 of them, so bear with me. And then the second part of this presentation, I'll hand over to Charles, and he's going to talk to you about, well, now that you know that you do provide designated services, well, what do you need to do? Okay. So as I said, a lot to go through today, and we know everyone's a bit anxious about it. It is a big change for both of our industries, lawyers, accountants, other service, professional service providers. So I do encourage you to leave your phones aside, turn your emails off, just concentrate, because even though it is a 1 July start date, there's a lot you need to do in preparation for that, as Charles will take you through as well. Okay, so just a brief introduction about money laundering. So why are we here today? Really, it's because the government has decided that professionals like us need to now contribute in combating these financial crimes. So if you're new to money laundering, what it is really is someone, a criminal, takes what we call dirty money, and they, for example, proceeds of drug crime, and they place it into legitimate systems such as banking accounts. They might buy assets with that money. They might move it around a few times. This is called layering, making it really hard for enforcement authorities to track. And they might also do this using complex structures which hide their identity, because as we know, criminals like to stay anonymous. And then what they'll do, they'll extract that money back in what appears to be like a legitimate payment. For example, it might come back out as a salary or a dividend. And this is called laundering. So they're trying to clean the money. Now, obviously, it's still dirty money, but they're trying to use legitimate systems to make it look legitimate. Okay, so from 1 July, professionals like us have these new obligations. Now, it doesn't matter about your qualification. It's not about whether you're a lawyer, whether you're an accountant. It's about what services you provide. So these services are what are called designated services under the Act. If you provide a designated service, then you're in scope and you've got to do things. If you don't provide a designated service, even if you're an accountant, then you're out of scope. Now, don't try to convince yourself you're not in scope. You need to do the work to determine whether you're actually in scope or not. So these new designated services will be set out in Section 6, Table 6 of the Act. Okay, so it's Table 6. Today, we're not dealing with any other designated services under the Act. There are already designated services that apply to banks, etc. We're not dealing with those. We're just dealing with these new designated services that sit within Table 6. Okay. All right. Now, if you haven't done anything yet, don't panic. It's February, but you need to start doing something now. Now, the first thing after this session I would advise you to do is go to the 𝗧𝘅 website. The 𝗧𝘅 website, 𝗧𝘅 is the regulator. They know this is a great imposition and inconvenience for our businesses. So they've spent a lot of time and money trying to make this as easy as possible. So they've got lots of things on the website that explain the changes. They've got, Charles will talk about starter kits that might be up there. There's questionnaires for you to fill out to see if you're regulated. There is a check if you're regulated section. Now, when you get the slides, if you click on that orange link there, that should take you to that section. And it's a questionnaire you can do yourself to see if you're regulated. But to do that section, you really do need to understand these designated services. So let's get cracking. Now, I want you to keep this in mind for each of the designated services. This applies to all of them. So for each, the service must be provided in the course of carrying on a business. So anything done in your personal capacity, not in your business, is out of scope. It must have a geographical link to Australia. So I'll talk about that. And when there's a sale, purchase or transfer, often orders of court or tribunal orders are excluded. So they're not in scope. Okay. So let's talk about this geographical link to Australia because it's a little bit broader than you might think. So this is going to be established where the service is provided at or through a permanent establishment in Australia. So for most of you, if you've got your firm through an office in Australia, that's enough to have that geographical link. It's also satisfied where you're an Australian resident and you provide the service through a permanent establishment overseas. So overseas offices and services provided by them can be included. Also, if you are a subsidiary of an Australian resident company and you provide the service through an overseas permanent establishment. An example of that might be an offshore subsidiary offering trust or corporate services in another country. So that still satisfies that geographical link to Australia. So once that's ticked, now that slide is not coming up properly. Let me go back. Oh, there it is. Okay, so here I've put them all on one page for you, a summary of these new designated services. We're going to go through each of those in a bit more detail. Okay, so I'm not going to read all those out, but they're there on a single slide for you if you need a quick reference. Okay. These useful guidance tips I want you to keep in mind as we go through each of the services because you really need to think about this in light of the service. Okay, so, and you'll find these on the 𝗧𝘅 website as well. So the first one is planning and organising will extend to preliminary and preparatory steps that directly advance the outcome of the service. So for an example of this might be, let's say share sale is going to happen. You might assist with the heads of agreement or non-binding indicative offer for the share sale where there is a proposed buyer. So that action where there is a buyer and a seller in scope, okay? So it doesn't have to be actually doing the share sale. It could be that preparatory step. Assisting, planning, organising or otherwise acting for on behalf of a person will only be regulated when it's sufficiently linked to the designated service. So you might see like pure advisory or incidental work that doesn't move a transaction forward by itself. It's just a purely advisory piece on the side. Your assistance must directly advance the outcome and not merely influence. So we do get questions like, I'm just giving CGT advice on this transaction. Is that a designated service? Possibly not. If that's all you're doing and you're not actually involved in assisting with the share sale or doing these other things, then it's probably just incidental and not in scope. Now, it's going to be difficult for you as businesses each time to make that judgment call and think about you have to train your employees on this as well. So if there's any doubt, our advice would be just consider it in scope and Charles will tell you what that means about what you need to do. But it's mainly you need to do customer due diligence on the customer in that situation. Okay, so think about these each time. I'm going to take you through the 9 There's my attempt at a graphic. That's the only one throughout the whole presentation, so enjoy that. All right, so the designated services. Item 1 is about real estate. So assisting in the planning or execution of a transaction to sell, buy or transfer real estate. Now, just note that real estate could be overseas, but if you're providing the service from your office in Australia, it's still a designated service, and court and tribunal ordered transfers are excluded. Now, let's look at some practical examples. Now, these are what I think are in scope and likely out of scope. So as an accountant, you might be coordinating with financial institutions to discharge a mortgage. You might act under power of attorney for a company to sign documents for the contracts. You might actually be the liaison person coordinating that settlement on a client's behalf. We know we all have clients that are very busy, high level. They just want someone else to deal with things for them. If you're acting in that role, likely providing a designated service. And assisting families with restructuring real estate, also in. Now, what might be out of scope is that, for example, general non-transaction specific tax advice, where you might give CGT or land tax modelling advice before someone buys a property. And of course, court and tribunal ordered ones are excluded. Okay, so you can see an example of an incidental advice that might not be directly a designated service there. Okay, item 2 is about change in ownership for companies and other what they call legal arrangements. Okay, so assisting or otherwise acting for a person in the planning or execution of a transaction to sell, buy or transfer a body corporate or a legal arrangement. Now, this is just not about share sales in companies. Legal arrangements include express trusts, partnerships, joint ventures, unincorporated associations, and similar things in foreign jurisdictions, okay? So let's look at some practical examples for accountants. For a share sale, you might prepare the completion accounts. You might calculate final price adjustments on a share sale, like earnouts, for example. You might coordinate changes to the company registers and asset changes in scope. Unit trust, similar things. You might collate the unit transfer forms, update the registers. For partnerships, you might, finalize partnership accounts in connection with the change in partnership ownership. If you're just doing accounts for a partnership outside of a transaction, that's not in scope. That's just purely doing accounts and financial statements. But if it's in connection with a transaction and you're, advancing that transaction by your actions, then that is a designated services, because we're looking about change in ownerships here. Remember the idea about money laundering is people using that money to put it in, buy assets and transfer it around. Out of scope, so general tax structuring or valuation advice given before there's any parties to an agreement. Once there are two parties and this transaction is looking like it's proceeding, more and more likely your assistance is in scope as a designated service. If you're just doing post-settlement compliance, after the fact advice about transfers, is it lawful, etc., not in scope, because the transaction's done at that point, unless, of course, you were already involved in the transaction. So that's item 2. Item 3 really is about receiving, holding and controlling client assets. So receiving, holding and controlling, dispersing or managing a person's money accounts or securities, etc., or property as part of assisting the person in planning or execution of a transaction. This is about also transactions, but you are involved in holding client property. Okay, things to note: must be in connection with a transaction. There are specific exceptions. I haven't noted all of them, but including payments held by you for your fees for acting in the transaction. That's just merely an incidental part of the transaction. It's not actually advancing the main purpose of the transaction. All right, I've got some examples here. So if you, in your trust account, you hold escrow or retention sums in connection with a transaction, if you are actually the one authorising payment of monies from the client's bank account for a transaction in scope, likely out of scope. I'm not going to go through every one of these examples just because of time, but likely out of scope. You give pure advice or calculations only. You're not handling the client funds. If you're doing routine bookkeeping or payables unrelated to a specific transaction being planned, That is not in scope. And again, payment of your own fees, not in scope there. Okay. Equity or debt financing, item 4. So this is about assisting someone in a transaction for equity or debt financing relating to a body corporate or proposed body corporate or a legal arrangement. So remember, legal arrangement includes express trust, partnerships, etc. Okay, so things to note: applies to equity raisings, for example, sharing unit issues, and debt financing, so loan facilities or other credit arrangements. Now, proposed entities are included. So assisting to line up funding ahead of entity formation is also covered by item 4. And there's no court or tribunal order exclusion for this item. So if you're doing any of this, you're assisting that person do this, then in scope, okay? Examples there. So even if you're just helping someone with their conditions precedent for their loan drawdown, likely in scope. You're involved in company raising funds by unit or share issues. You're helping with that term sheet where you've got known investors coming in. Convertible note transactions, they're also included in here, okay? Likely out of scope, advice not tied to a specific financing transaction. Post-financing advice, the transaction's already completed at that point. Services to members of your own business group, so internal to your corporate group, not included. So these are really services you as a business are providing to a customer, okay? So customer is not someone within your internal business group. So if there's any in-house accountants or lawyers on the call, if you're just doing things for your own employer, unlikely to be within designated services because you're not providing to a customer and you're not running your own business unless you have a separate business that you contracted directly to that employer for. So these are really about carrying on these activities in a business. Okay, so item 4. Item 5 is about selling or transferring a shelf company. So this is really, shelf company is what we all know to be a company hasn't traded, no assets or liabilities. And this is really about, shelf company providers. If you're setting up a shelf company for somebody, that's not item 5, it's an item 6 matter. So I might just go directly to item 6 and talk about that. Someone's asking about the slides and recordings. Yes, I do believe we will give the slides after. So yes, we've had a few of those questions pop up. Item 6 is about creating or restructuring a company or other legal arrangement. So this is very typical of accounting firms. You're involved in, structure creation. Okay, so assisting a person to plan or execute or otherwise acting on behalf of a person. See those words there? It doesn't actually have to be your client. If you're assisting someone do this, but your engagement agreement is with another business, you've really got to look at the substance of who you're assisting. So you could still be in scope there for the end client. So creating or restructuring a company or other legal arrangement. Okay. Unique to item 6 is a broader range of what we call customers for the purposes of these designated services. And Charles will talk to you about what you need to do with a customer if you're in scope. A customer, one of the things you do need to do is customer due diligence, verifying who the customer is. For this item 6, the customer is the person you assist and where a company is created, also the beneficial owners and directors, the controllers of that company. And for an express trust is also the trustee, settler, etc. So this is unique to item 6, expanded definition of customer for this. Now, just for the purpose of legal arrangement definition, testamentary trusts are not in scope. So if you are just assisting a customer set up a will with a testamentary trust, even though you are creating a trust upon death, that is not what the legal arrangement definition is covering, okay? Okay, here's some examples. So for company formations, you're involved in preparing constitutions, consents to act, etc. Trust formations, you assist with the trust setup. You know, even if you're just giving instructions to a lawyer on behalf of the end client, I would consider that, if you're actively involved in that and advising on the structure, I would consider that as a designated service. We will probably get more guidance on this when sometimes it is confusing when there's a number of different advisors involved and determining the roles of each person. But as I said, if you're in doubt as to whether you need to do the customer due diligence, probably just do it anyway. In any event, it's good to know who you're dealing with. Restructures, this is in scope for item 6. Rollovers, you know, if you're coordinating a rollover and doing the restructure there, in scope. Likely out of scope, again, this pure advisory piece, you know, should we use a trust? Until you actually get to that trust set up, just advising on the pros and cons of using a trust, not in scope. If you're transferring existing companies or trusts, this is not item 6, this is item 2. And why that matters is because of the due diligence piece. Post restructure advice, you know, was this lawful or an optimal structure? Sometimes you might give advice about a structure that another accountant has set up, out of scope at that point. You know, advising on eligibility for rollover relief without taking steps to implement a transaction, that is likely out of scope for item 6. Now, items 7 and 8, I'm going to deal with together. These items are about, remember I said that criminals like to disguise their identity. So this, where a person nominates another person to act as a director or office holder or a shareholder of a company, that's a great way to disguise their identity, really. So these are quite high risk ones, I would say. Related to this also is item 9, which is about offering your office as the registered office or place of business for a company. These are all about criminals wanting to disguise their identity. So item 7 is about director and office holder positions. So acting as or arranging for another person to act as any of the following on behalf of a person, the nominator, in the course of carrying on a business. So remember, again, these are all in the course of carrying on a business. Director, secretary, a power of attorney for a company or legal arrangement, partner in a partnership, you know, if you've been asked to act as a trustee of a trust or something similar in a foreign jurisdiction. Again, about hiding identities. Item 8 is about shareholders. So arranging for acting as or arranging for another person to act as a nominee shareholder of a body, corporate or legal arrangement on behalf of the person, the nominator. Okay, things to note for items 7 and 8. Item 7, there are some exclusions, court and tribunal ordered. You'll find these exclusions probably on the AUSTRAC website as well. And for customer due diligence, the customer is the nominator. So who's nominating you or asking you to act or arrange for someone else to act as their representative on the board or in the shareholder? Now, I think like this area is probably higher risk. So particularly for shareholder nominations, you've got to be asking yourself, why does this person require me or require someone else to take up these positions? Okay. And you see with accountants often, you know, an overseas company might ask you to be a resident director because that's required by the Corporations Act for a client company. So that's in scope. You're appointed as trustee of a trust. You accept a power of attorney to act for a client's company or its trust. Out of scope, you know, merely introducing a possible candidate might fall short. But once you start taking those steps to, you know, appoint them, etc., probably you're in scope at that point. Just note, power of attorney appointments for natural persons, they're out of scope here. This is not what this is about. Acting as a trustee of a testamentary trust, out of scope. General advice, you provide high level advice on whether a nominee shareholder is appropriate. At that point, it's still just purely incidental, pure advice. But once you start taking the steps to implement that shareholder nominee, appointment in scope. Okay. I'm just watching the time. I'm pretty good for time, actually. So item 9 is the last one, which is providing your registered office or principal place of business. Okay. So providing a registered office or principal place of business address of a body, corporate or legal arrangement in the course of carrying on a business. Now, we see this all the time. Accountants like to offer this as a service. We understand. And for example, you offer a registered office service for ASIC regulated companies, for mail handling, statutory notices, etc. So that's in scope there. So a lot of you, I think, that's just going to be part of your offering and you will be in scope there. Okay. I think that was all from me. Okay. So I'm going to hand over to Charles now. So once you've kind of looked at your services and you've decided, okay, yes, I do provide designated services, what do I need to do? So Charles.
Thanks, Gina. Hello, everyone. Good to be here. This second half of our session, we're going to focus on what are the AML CTF obligations on accountants as part of the Tranche 2 reforms. So if you provide any of those 9 new designated services, which Gina has just gone through, you'll be regulated and you need to start thinking about how do I comply. So AML CTF compliance is a massive area. It can take up a lot of time. We don't have much time today. So the purpose of our discussion is to focus on what we have called key obligations for accountants. And we've got 6 of them. So on the slide there, we've got enrollment. You must enroll with 𝗧𝘅. You must develop and implement an AML CTF program. You've got to get your team ready. There's certain obligations that you'll have to do due diligence on your staff and train them. You've got to set up corporate structures or governance structures and oversight. We're going to talk briefly about customer due diligence requirements, monitoring and reporting obligations, and then round out the discussion with a few comments about record keeping. So enrollment. So if you provide a designated service, whether that's one of the 9 Gina talked about a moment ago, or any of the other existing designated services, and there's a geographical link to Australia, you must enroll with 𝗧𝘅. And that enrollment is on the reporting entity's role. The obligation is really black or white. You're in or you're out. Have you enrolled? You have a deadline for enrollment. The enrollment deadline is 28 days after you provide the designated service. So for our new designated services, the new laws start on 1 July. And given that, the 28-day rule means you must enroll no later than 29 July this year if you're providing any of the new designated services. For those businesses that are super organized and want to enroll early, there is a possibility, not yet, hold your horses. It opens at the end of next month. So 31st March is when enrollment will open for Tranche 2 reporting entities, accountants, lawyers, real estate professionals. So I would encourage everyone to enroll early. Don't leave it to the last minute. Don't leave it to June and start thinking about enrollment. You should start thinking about it now. What do I need to enroll? What information do I need? How do I do it? These are the types of things you should be thinking about now. If you leave it to the last minute, that's not a good way to handle it, especially from a governance and compliance perspective. You will miss certain things and that may cause you grief later on. Quite helpfully, 𝗧𝘅 have issued some guidance around enrollment. And the good news for all the accountants tuning in today, the enrollment process is relatively simple. It's easy, straightforward. It's a simple process of setting up an account with 𝗧𝘅, filling in an online enrollment form. In that enrollment form, you'll be required to provide certain basic information about your business to 𝗧𝘅, including its structure, the services you provide, key personnel, and some contact details, amongst other things. Helpfully, there is a guide, as I mentioned. I've it's been around for a long time. It probably needs a little bit more of a refresh. AUSTRAC have amended it recently for the Tranche 2 reforms. But in that guide, it does contain some helpful information about and commentary, I have to say, about the questions that you'll be asked in your enrolment form. So I would encourage you to have a look at that guide. We have a link on the slide there, and have a good read and have it handy when you are enrolling so that you can refer to it. Once you have completed your enrolment form, there will be a section which is called a declaration, which the person submitting the form will need to make. They'll need to declare that the information contained in the enrolment form is true, accurate, and complete. Now, this is a really serious matter, because providing false and misleading information to AUSTRAC is a criminal offence, and there might be civil penalties as well. So it's not a matter that should be taken lightly. As a practical tip, I would encourage anyone who is enrolling to prepare a draft enrolment form, print it out, review it carefully, and make sure your compliance officer and your governing body carefully review that draft form and approve it before it is enrolled. And that way you're mitigating your risk that that any details that you provide to AUSTRAC are false or misleading. When you have enrolled, there is an ongoing obligation to update AUSTRAC if there's been any changes to your business. So, for example, if you cease providing one or more designated services, you've got to go online into your profile, update your enrolment, and you have a time frame to do that. It's 14 days after the date of the change. So it all sounds simple. That's the simple part. More complicated part is the development and implementation of an AML CTF program. You're probably thinking, what the hell is that? And to break it down, it is a written program or document which will contain information about how you identify, manage, and mitigate the risk of your products and services being exploited by criminals for money laundering or terrorism financing purposes. What a mouthful. So what the regulation has been how it's been drafted, it's been drafted as a risk-based approach to regulation. What that means is that the government has allowed for reporting entities to tailor their AML CTF program to mitigate and manage the risks as they see fit, given what their business does. And it also allows for the allocation of resources to areas of your business which you may identify to be the high risk areas of your business, or which may have the most impact should some events occur. The reason for the risk-based approach to regulation is that not all money laundering and terrorism risks are the same for each business or each customer or each transaction. So that's why we have this risk-based approach to regulation of money laundering and terrorism financing. Now, as part of under this risk-based approach, you are required to do reporting entities, including accountants regulated by the Tranche 2 reforms, are required to do two things. First is a risk assessment, and a risk assessment is an assessment of your business to determine what risks your business faces in terms of money laundering and terrorism financing. So it's about identification of those risks, and there's also an assessment of those risks. What is the probability of those risks occurring, and what is going to be the harm to my business if they do eventuate? The second obligation under a risk-based approach is to develop and maintain appropriate policies, procedures, systems, and controls to manage and mitigate your money laundering and terrorism finance risks. So your AML program will be comprised of, number one, your risk assessment, and number two, your AML CTF policies. So if you're getting a bit overwhelmed at the moment by this sort of creation of an AML CTF program, you're not alone. It's a big job and can be quite confusing and difficult to understand what to do, especially if you're a small accounting practice and perhaps you don't, and perhaps your background is not in finance or gaming or traditional industries which have been regulated by AUSTRAC in the past. So quite helpfully, AUSTRAC has identified this issue and realizes that it's quite a large compliance burden on the profession. So it has created what it has called a starter kit. There's a link to the starter kit on the slide. There's one for different sectors. There's one specifically that has been developed by AUSTRAC for accountants, called the Accounting Starter Kit. I've had a look at it. It's quite good. The reason for AUSTRAC has developed the Accounting Starter Kit for a particular form of accountancy practice. It's not for everyone. There are certain assumptions and there's a certain profile that you need to fit in order to ensure that the starter kit is suitable for your business. The starter kit is designed to assist a small accountancy firm, which is less than 15 staff, that provides designated services to low-risk clients to help them create and maintain an AML CTF program. So it can be a very useful tool, especially if you fit that profile. Essentially, AUSTRAC has taken a great deal of the compliance burden or liability off your shoulders and prepared a form of document or documents and templates that you can use to develop your AML CTF program. So I'd encourage everyone to have a look at it. Even if your business doesn't fit that profile, it would be a good starting point to get you familiar with certain terms and concepts. And you could potentially use what's in that starter kit to customize it to your business. Now, if there's a lot of amendments that need to be made to the base documents, you might be thinking, well, maybe it would be better if we look at an alternative for development of our AML CTF program. And there are providers out there that can assist you on that front. In the starter kit, there's a risk assessment. There are policies and procedures. There are also forms which you can use daily in your business. So when you combine those documents after customization for your business, those documents will form part of your AML CTF program. Once you've developed your program, it's got to be approved by a senior manager of your business, and it's got to be kept up to date. So it's got to reflect changes in your business and also AUSTRAC guidance, which is released or updated from time to time. The AML CTF program must be independently evaluated once every 3 years, and that evaluation process can be done internally or it can be done externally. It may be possible for you to form a reporting group, especially if you are part of a large corporate group and there's many reporting entities within that corporate group. It is common. It may not be so common for accountancy practices, but if the option is available of forming a reporting group, what that means is you'll have a lead entity for the group. There'll be ordinary members of the group. The lead entity will be the point of contact for AUSTRAC and will oversee overall compliance for the group. Each member will still have the legal obligations to comply, but you will see that there can be some efficiencies in terms of risk management and potentially compliance costs by forming a reporting group as well. Now, after you have created your AML CTF program, the next step is implementation. Implementation will be key to compliance, and your staff will be fundamental to your implementation piece. You can have the the best AML CTF program in the world, but if you fail in terms of implementation, your program will not be effective. So your staff, very, very important in terms of compliance. It is very important that you prepare your staff for these reforms. They will be critical to ensuring they help you meet your AML CTF obligations.
Charles, sorry to interrupt. I do have a couple of questions coming in. It's a hot topic in the chat about offshoring and who counts as staff when we're talking about staff. Now, if that's too big a question to answer, just let me know, but there's a lot of people asking.
Yeah, sure. That's probably a larger topic for discussion. 𝗧𝘃 will deem staff to include any persons that work in the business. I'll talk about personnel due diligence now, conveniently. And that's really about ensuring that your staff are fit to perform the roles in your business. So ensuring that you have the right persons in those roles will require you to undertake what 𝗧𝘃 refers to as personnel due diligence. That means undertaking certain inquiries in respect of your staff to ensure that they are the right persons performing the roles. Now, those inquiries might be identity checks. Are they who they say they are? It might be background checks, including criminal history checks, employment checks, qualification checks, and reference checks. The central principle here is you don't want to let people in the door of your business who might be compromised in some way, unethical, or unqualified, especially those people that are performing high-risk functions in your business. So if you're offshoring, you've got to ensure that your money laundering and terrorism financing risks are being mitigated. What practices have you adopted, systems and controls in your business to ensure that that risk has been mitigated? So it's all part of that risk-based approach to determining what is the appropriate systems and controls for your business in order to mitigate and manage your money laundering and terrorism financing risks. Hope that was a little bit of information there on that front. It is a large topic. I don't believe 𝗧𝘃 have provided official guidance on that particular subject. I'm sure they will at some point in time, but happy to sort of take some questions on notice about that as well. The second component of getting your staff ready is ensuring your staff understand their AML CTF obligations. And in order to do that, you need to ensure that you have training for your staff. Training is key. We want to ensure that the personnel in your business understand what are the AML CTF obligations of your business, what are the consequences for non-compliance, what are the AML CTF, what are the money laundering and terrorism financing risks, and what are your business's appropriate systems and controls. Your people will be the gatekeepers to compliance. They need to be aware of all of those matters. The last component of getting your staff ready is in terms of ensuring your business has strong governance and oversight in place. So 𝗧𝘃 has identified 3 key roles for a governance structure, which include, number 1, a governing body, which has primary responsibility for governance and executive decisions, and they will be the entity which oversees compliance at the highest level. Next, you'll have senior managers who approve key AML CTF compliance decisions, And lastly, you'll need to appoint an AML CTF compliance officer who will manage the day-to-day AML compliance and ensure policies, procedures are implemented. That person will also be normally the point of contact for 𝗧𝘅 and will handle the mandatory reporting obligations as well. There are requirements for who can be a compliance officer, and they include, they've got to be a senior person in your organisation, they've got to have access to your governing body, they've got to be an Australian resident, and they have to be a fit and proper person. And the fit and proper person test is sort of your normal one that you find with a number of laws in Australia. They've got to have no issues in terms of bankruptcy or insolvency, no serious criminal offences. They've got to be of good character and integrity, for example. The next key obligation on accountants regulated by the Tranche 2 reforms is the requirement to undertake customer due diligence, or CDD. So CDD is all about collecting and verifying customer information. And you would do this in order to help you understand who your customers are, who you're dealing with, and the money laundering and terrorism financing risks they may pose or expose your business to. The two forms of customer due diligence, there's initial CDD and also ongoing CDD. Initial CDD is about establishing certain matters about a customer before providing a designated service. So this will normally include establishing the identity of your customer or their representatives. You'll need to do your 100-point check to verify their identity. That will normally include getting a verified copy of their current driver's license or current passport. And then there's a whole heap of different combinations or permutations in which you can verify your customer, but also will include establishing the identity of any beneficial owner of your customer if they're a company or trust. So initial CDD can be quite tricky sometimes, especially if your customer has a complicated corporate structure, ownership structure, which is multi-layered. Can be quite difficult to ascertain who are the controllers and ultimate beneficial owners in the group. Now, it is the overarching objective here is to work out who are the natural people behind the structure, pulling the strings, and identify them. As part of the initial CDD, you'll also need to establish whether your customers are designated for targeted financial sanctions, which may prevent you from dealing with them in a particular way or their assets, and also identify whether or establish whether they are a politically exposed person or a PEP. We love an acronym in this space. A PEP is really a senior or high-ranking government official, and includes their family members and close associates. Once you've done your initial CDD, you still will be required to undertake ongoing CDD, and that will involve monitoring and managing your money laundering and terrorism financing risks throughout the course of your customer relationship. And that will include monitoring transactions and behaviours for suspicious activity, updating your customer's risk profile in response to certain events occurring or triggers, and reviewing, updating, and re-verifying information as required. Now, regardless of whether your CDD is initial or ongoing, the overarching principle is the level of information you need to collect and verify will be completely dependent on the risk profile of your client. If your client or customer is high risk or deemed to be high risk, then you'll need to undertake further inquiries. This type of further inquiries is what is referred to as an enhanced CDD. For example, a high-risk client might be someone that is dealing with countries on sanctioned lists, that has a opaque and complicated ownership structure, or might be dealing with complicated products and services. If your customer's low risk, you can apply simplified CDD, which means that you can take the foot off the pedal a little bit in terms of your collection and verification of information. But that, I stress, is only for low risk customers. Low risk customers might be those that are already regulated by existing Australian laws, that are purchasing low value products and services from you, or have a very simple corporate structure or ownership structure. Now, you're going to have existing customers. Customers that you have already are called pre-commencement customers. AUSTRAC has issued some guidance which says that until your pre-commencement customers, until certain events occur with respect to them, you will not be required to undertake initial CDD or ongoing CDD. And those events will be if you're required to submit a suspicious matter report, or the risk profile of your pre-commencement customer moves from low to medium or high risk. And the reason why AUSTRAC have done this is to reduce the regulatory burden for accountants. Our fifth key obligation for accountants is monitoring and reporting. So AUSTRAC will require each reporting entity to have in place a reporting monitoring program to ensure that it can detect any suspicious activity or unusual transactions. Now, in your monitoring of your customers and services, if you detect certain abnormalities and something unusual, that might trigger red flags. And if there are a red flag, you'll need to go in and have a look at what's happening, what's going on. It may require you to undertake further CDD, or it may in fact require you to make a report to AUSTRAC. If you are required to make a report to AUSTRAC, there's 5 key reports that need to be made, which are set out on this slide here. A suspicious matter report must be made if you suspect a person isn't who they say they are or claim to be. There could be issues to do with their identity, or you have information which relates to criminal activity. So if you form that suspicion, there are deadlines for lodging that suspicious matter report. If the matter relates to terrorism financing, you've got 24 hours, quite a tight time period. If it relates to any other matters, you need to lodge your SMR within 3 business days of forming that suspicion. Threshold transaction reports. That's to do only if you're dealing with cash and the amount of the cash is over 10,000. That's when you receive cash. Someone hands you a bag of cash, or you pay cash. So that may pop up from time to time. It may not. A lot of clients these days are cashless, and we deal with electronic payments. The next 2 reports relate to have an international perspective, and they won't necessarily be applicable to all accountancy practices. International funds transfer reports is about when you receive instructions to transfer funds into or out of Australia. For example, if you receive an instruction to transfer within Australia to make available funds in a foreign jurisdiction, that would be caught. If you receive an instruction from outside of Australia to make funds available in Australia, that's also caught as well. I appreciate that some accountancy firms may not ever deal in that space, but just highlighting that now. Cross-border movement reports, that's to do if you're moving physical cash across borders, and the obligation to report is on the sender and receiver of that cash. The last form of report is a very important one. It's one that every reporting entity will need to deal with and will need to submit every year. It's a compliance report or an annual report. And in that report, you'll need to answer a series of questions and lodge that with AUSTRAC to prove and establish how you are meeting your AML CTF obligations for the previous calendar year. Now, you're required to lodge that report between January and March of each calendar year. Our last key obligation on accountants from AML CTF perspective is keeping records. Making and keeping proper records seems so simple, but it shouldn't be overlooked. Your records will be very, very important when it comes to establishing whether your business has complied with its AML CTF obligations. If you are reviewed or investigated by AUSTRAC, or if you are going through the process of your regular independent evaluation, you'll need to produce records. And if you can't produce those records, your auditor or assessor, evaluator will assume that there are no records and you haven't done what you say you have done.
So interesting questions coming through on that, because the Tax Practitioners Board currently does not recommend that tax agents retain identity documentation copies because of risk of identity theft. So there could be some changes there, and maybe the Tax Practitioners Board might have to update its view.
I think so, yes.
Yeah, I mean, you don't necessarily, correct me if I'm wrong, Charles, you don't necessarily have to keep the copies of the passports, the licenses, etc., but you do need to keep a record that you verified it. So you might have a tick sheet saying, yes, I saw this, I saw that, because there are privacy risks and data breach concerns that people do have. So it is a good question.
The overarching principle here as well is you need to comply with your customer due diligence requirements. And how do you do that? You need to maintain adequate records to prove that you've undertaken the relevant steps that you're required to do in terms of CDD. So it does seem like there's a bit of conflict between, what professional bodies are advising and federal legislation. So that'll be an interesting topic of discussion over the next coming months.
Just looking at the time. Do you want
Yes, I think my last point is you've got to keep those records for 7 years. Look, we've dealt with 6 key obligations here. There's been a lot of information. So I just wanted to talk now about some practical steps, what you can do now to get ready to be compliant 1 July in terms of the Tranche 2 reform. So firstly, you need to look at your business. What are the services you provide? Are they designated services? You've got to map your services against designated services. Are they one of the 9 new designated services? If they are and they have that geographical link to Australia, then you're caught. We've got to comply with the AML CTF laws. Secondly, if you are regulated, you've got to perform a firm-wide risk assessment. And that risk assessment, again, is to identify what money laundering and terrorism financing risks your business faces and what are the severity of those risks. You need to develop and implement a AML CTF compliance program. And again, here, if you fit the profile of a small business providing low risk designated services, or rather designated service to low risk clients, then take advantage of the accounting starter kit. It's already there, laid out for you. It will reduce your compliance burden. You've got to update your procedures, in particular client onboarding, data collection, verification procedures. All of these need to be integrated into your business, and you need to make sure that this new regulation will not have a large impact, or will have a large, but you need to minimize the impact on your customer experience. Training, you've got to get your people trained up. Really, really critical. You should be doing that now. You should take steps now. Don't wait until 1 July. Your people need to be aware of what your obligations are, what the risks are to your business, and how you comply. Lastly, you've got to prepare your IT systems and documentation processes for reporting and monitoring obligations. Now, there are software packages out there you can access in terms of this space. I would encourage you to have a look at them. Some businesses might suit a manual reporting and monitoring program. I don't know if that's going to be suitable for everyone. I suspect larger organizations, more complex organizations and businesses will greatly benefit from a monitoring technology package. So those are my sort of practical steps.
I will say this, if you're sitting there with high anxiety, which probably a lot of you are, now this is understandable, I would just like to say openly, 𝗧𝘅 has said they're not expecting perfection from day one. So that doesn't mean sit now and do nothing. That means go to the 𝗧𝘅 website, get your ducks in a row. But the one thing that's very black and white and that they will start with compliance enforcement on is if you haven't registered and you should have registered. So if you are clearly, and your website says I'm providing all these services and you have not registered, is a very quick way to get yourself in trouble. The other stuff, look, we've all got to try our best. We're all in this together. We, as well as lawyers, we're doing it. It's not easy. There's a lot of questions in there about, what do I need to do for the customer due diligence process? First step, go to the 𝗧𝘅 website. There's a lot of information on there. Just spend the time and do it. And there's a lot of questions also about, the 3 roles you need to appoint in your business. Can they be the same person? Obviously, yes, if you have to have it as the same person, you might be a sole trader. Obviously not great from a governance and checkpoint perspective, checks and balances.
I will say that 𝗧𝘅 do appreciate with smaller businesses that those 3 roles might and often will be performed by the same person.
Yeah.
So they appreciate that, they understand that, but in a perfect world, from a governance perspective, then it would be better those roles are performed and discharged by different people.
Yeah. And there were also a lot of questions out there about, is this court, is this court, is this court? I will encourage you, if it is in a grey area, you're not sure, just treat it as a designated service, particularly if you're already in scope and you've got to do your compliance program, you've got to train your staff anyway, because this is about, for each matter you do, is it a designated service? Now, if you as the senior manager are not sure, how are your staff going to be sure? So probably, and some of you might just do this anyway, across your whole business, treat every matter as though it is a designated services, particularly just for the customer due diligence piece. Because otherwise you're probably going to get yourself in trouble. You're relying on your staff to make those assessments. It's difficult sometimes. Sometimes you're in a grey area. Just remember, it's about your involvement and are you actually progressing that transaction, the subject of the designated service in the course of carrying on a business. Was there anything else?
Yeah,
Thanks, team.
Sorry, just from an enforcement perspective, 𝗧𝘅 has said that it's not going to go after those businesses that are trying to comply. It doesn't want to know. It doesn't want to target those businesses. It wants to target those businesses that are willfully blind.
Yeah.
So those businesses that know of the regulation or should know of the regulation, but they take no steps whatsoever to comply. Those are the businesses that 𝗧𝘅 will really be targeting. Yeah. Initially anyway.
Yeah, at least at the start.
Yeah.
Thanks, team. There's so much in this and there were so many great questions. I've been doing my best to answer them as we go in the Q&A and dropping in 𝗧𝘅 website things. I'll hand us back to Vicky to wrap it up a little bit. But thanks for your attention, everyone.
Awesome. Thank you so much, Gina, Charles, and Jane. That was like a lot to pack in 1 hour. Q&A, Jane, do you want to take any more, or are you satisfied with the dozens that you've already answered? And I know Gina and Charles already answered some.
Yeah, I know we're running out of time, so thank you for your patience. Some of you might be coming back to watch this last little bit if you're feeling super keen. There were 2 questions that stood out to me. One is for those people who act as registered officers for their clients. A lot of them are suddenly rethinking whether that's a service that they want to offer. So the main questions were, what do I do for all the clients that I'm already the registered office for? And then secondly, if I decide I don't want to do this, can I get out, stop being the registered office for all of them by 1 July, and am I then all good on that front?
It's a good question, actually, the first one, because you're going to be continuing to provide that service post 1 July unless you change the registered office. So they would be pre-commencement customers for the purpose of customer due diligence. But I would say that you're in scope in terms of providing designated service. So you're probably going to have to do your AML program. If a suspicious matter comes up, one of these matters, you have to think about reporting it. But one thing we didn't cover off, really important as well, is if you do need to lodge a suspicious report with AUSTRAC, you cannot tell the person, you cannot tell your customer. That's called tipping off. It's a criminal offence. So really important, you tell your staff as well that you cannot tell your customer if you're going to report them. So keep that in mind. Yeah.
And then I had a question about Division 7A. Sorry, tax nerd over here. I see Division 7A, I get very excited. So the question was, if I'm helping prepare Division 7A loan agreements, is that intercompany financing? Is that a designated service?
I would say yes, but I will think about that and come back. But I would say yes, it is assisting with a debt facility, including related party matters. Yeah.
Okay. Those were a lot of the questions. There were a lot more questions than that, and I'm sorry to everyone that we didn't
there was a lot
all
of
of them today. You're not alone. There's a lot of people out there asking these questions, and this is new for everybody. So the good news is that there should be lots of resources coming from lots of different sources that can help answer some of those questions.
Yeah.
All right.
Awesome.
Wrap it
Thank
up.
you guys so much. I will
you.
skip the key takeaway bit because I'm sure Gina and Charles gave us a gazillion key takeaways, especially at the end there. So yeah, that concludes today's discussion on the AML CTF obligations for accountants. I hope everyone found that useful today. If you took one small piece of knowledge away from today, it's already super, I don't know, makes us happy as well. We will send out the recording of today's webinar along with the slide pack to everyone who's registered. Tax Science Academy subscribers will be able to access the recording within a few hours after the end of today's event. We've also included Charles and Gina's contact details at the end of the pack. So if there's anything that you think that you might need more help or complex assistance with, you will be able to reach out to them, but I don't think they'll be able to answer like all the questions that we still have open in the Q&A box today, but appreciate that we did get through as much as we could. So on behalf of the team at Tax Nuggets Academy today, thanks for spending time with us and tuning in, and we will see you all next time. Thanks, Charles. Thanks, Gina. Thanks, Jane.
Thank you.
See you. Bye.
Bye.